Good afternoon and welcome. My name is Tiffany Lee. I'm a partner here in the litigation group at Holland & Knight. I'm also the firm's firm-wide diversity partner, so I'm responsible for all that we're doing in diversity and inclusion, both internally and externally. And I want to welcome you to this voting rights litigation training program being sponsored by the American Constitution Society. As you've probably noticed, we are being recorded for future use, so we'll be recording throughout the afternoon. There's also going to be a reception immediately following the training program right out the door to the left. And then the final sort of housekeeping matter is that if you parked in the parking garage here before you leave, please see me so that I can give you validation stickers so that you don't pay the exorbitant parking fees in the parking garage. But we're very excited to host this. Hal Daniel, a partner in our Atlanta office, presented this opportunity to us, and we, our pro bono partner and myself, talked about it for all of 3 seconds before we said we should do this. Obviously, voting rights litigation is an important topic, and we're very happy that the American Constitution Society is here to train us all and enlighten us on things that we need to know. So with that, I'll turn it over to Zach Gima from the American Constitution Society.
Thank you very much. As Tiffany said, my name is Zachary Gima. I'm the Associate Director for Network Advancement at the American Constitution Society. For those of you who are not familiar with ACS, we're a national network of lawyers, law students, judges, policymakers, and academics who work to make the law work for people from across the country. If you would like to know more about ACS and become a formal member of our network, please visit our website, acslaw.org. I'm very pleased to introduce our partner in this endeavor, Jerry Hebert of the Campaign Legal Center. Jerry is the brainchild of this event specifically, and also has been involved with voting rights litigation for, say, a number of decades. If you've seen anything about voting rights litigation in the news, Jerry's probably had a hand in those cases, and so we're very, very, very honored that Jerry has been such a good partner with us, as well as the Campaign Legal Center. Jerry?
Well, thank you, Zach, and thank you to Holland & Knight for hosting this event, and what a special room that we're in, and for recording this also, so that other people in the future can hopefully take advantage of some of the observations. We have a great panel that we're going to bring up here in a couple of minutes. The panel that we've selected are people who I've known or have read their scholarship and have worked with. And so I'm very pleased. I think we have a pretty good representative group of people coming. Bernita Tolson is a law professor at Florida State who's written some very enlightening articles about the Voting Rights Act. And when I first read them, and I did not know her, I said, when we do a panel on voting rights in Florida, she's got to be on it. So I'm really grateful that she's here. We also have Nancy Abudu, who is a recent Florida transplant, who is the legal director of the ACLU of Florida, and someone that I litigated the South Carolina photo ID case with a few years ago, and Texas as well. So we've been in the trenches together. Neil Bradley is a longtime friend and someone who has taught me a lot about voting rights. Neil was the former associate director of the ACLU's Atlanta Voting Rights Project, has worked on cases. One of the few people I can actually say this about who's worked on voting rights cases longer than I have, which is getting to be fewer and fewer people. But Neil is just always has been kind of a lawyer's lawyer in the voting rights field. So I'm grateful that he's here with us today. And then my co-counsel from the Texas voting rights cases and redistricting cases and basically all litigation Texas is Chad Dunn, who's a partner at Brazel and Dunn in Houston, Texas. And I brought Chad along because this is all about training the next generation, so to speak, of voting rights litigators, or at least getting you interested in what area of the law that we have before us. And Chad is one of those who I think epitomizes the ultimate goal of what we're trying to do, which is to get really highly skilled trial lawyers handling voting rights cases, or even just handling minor voting rights matters. And at the very end of this whole session, I'll give a kind of what you can do if you're interested in staying involved or staying at least informed about these issues. I have found that, and I appreciate Zach's comment that you've been a great partner, ACS, in this endeavor. And even though, in a sense, the Voting Rights Institute is my brainchild, it actually was my wife's brainchild, who's here today, Victoria. And sometimes the Voting Rights Institute, which we've nicknamed the VRI, I sometimes think of it as Victoria Roberts Institute, since that was her maiden name. Because it was her idea when she looked around the room, I think in 2011, and saw kind of me as one of the younger people doing voting rights cases. She said, "Don't you think it's time to train another generation of people doing what you do?" So I want to acknowledge that she was really the brainchild. What I have found, and this is our fifth presentation across the country. We're going to more cities in 2015. It originally started kind of as an intense voting rights training, 4 nights in D.C., but then this year we moved on and kind of took it on the road, so to speak, to just kind of give you an overview of what the issues are that we're facing today in voting rights cases. And you'll hear from people who are actually writing about these issues or working on cases that are pending now, and do's and don'ts. I've found, though, that for a lot of people who don't do voting rights, that there's it can be a pretty steep learning curve. And so rather than just kind of throw a whole bunch of comments about voting rights cases, I thought I would just take a few minutes to open this up with probably 10 or 15-minute PowerPoint presentation that'll just kind of give you, I hope, an overview of the area. So the slides that I'm putting up right now are going to kind of just really, from a 30,000-foot level, talk about the Voting Rights Act, the biggest and other provisions of federal law. So I want to start with Section 2 of the Voting Rights Act, which is a nationwide provision. It was not involved in the controversial Shelby County decision. It basically says it's the major enforcement mechanism to the Voting Rights Act. And it says that, as you can tell, I've highlighted what I consider to be the most important parts of what is a fairly long statute, but it's a results test. You don't have to prove intent, so that's number one, so you'll see there. It's based on the totality of circumstances. And what you basically have to show under the Voting Rights Act is that a certain group of people who are defined, African Americans, Native Americans, Latinos, Asian Americans, that they have less opportunity than other members of the electorate to participate in the political process and to elect candidates of their choice, representatives of their choice. And there's nothing in the law that requires proportional representation. So you can't simply go in and say, African Americans are 20% of the city's population. They only have 1 out of 10 seats. They deserve 2 out of 10 seats, so therefore we win. So you always have to produce more evidence about that. And so the Supreme Court in the current Section 2 test, this is going to be, for me, a eyesight test in a way, because I'm having to look down the end of the table. Welcome. Grab a seat. We're just getting started. So the big leading case that continues to be out there that kind of defines the test for what Section 2 of the Voting Rights Act. And by the way, these slides, I'll email them to all of you at some point, so just make sure that we have your contact info so that I can send them to you. And it's a 3-factor test for determining, basically under Section 2, which is used mostly in redistricting cases or challenges to multi-member at-large election systems. You ask 3 questions. Is the group, meaning the minority group, sufficiently large and geographically compact to constitute a majority in a single-member district? So you basically have to draw a sample, hypothetical, illustrative, call it what you will, plan, and show that it is possible to create a geographically compact minority group into a single-member district in which they will comprise a majority. Now notice I haven't said a majority of what, and we'll come to that in a minute. Then you have to look at whether the minority group is, quote, politically cohesive. And what that requires is you have to prove that when there is an election held typically involving a minority candidate versus a non-minority candidate, that the minority candidate supports the minority candidate of choice in significant numbers, generally at least over 50%. And then and this is kind of the flip side of question 2, does the white population or the majority vote sufficiently as a block to enable it to defeat, in the absence of any special circumstances, the minority community's preferred candidate. So that's kind of, those last two questions really talk about racially polarized voting. Do the minority vote cohesively, and do the whites vote as a block against the minority candidate of choice? In Johnson versus DeGrande, a case out of Florida here that I was involved in, the Supreme Court decided in 1994, the court denied a Section 2 claim because it found that the minority groups constitute effective voting majorities in a number of districts substantially proportional to their share in the population in Florida. And they kind of added what we consider to be a fourth question, or a fourth prong to the three jingles prongs I just mentioned. Does the minority group lack rough proportional representation? And in a concurring opinion by Justice O'Connor, and this opinion in Johnson v. DeGrande was written by Justice Souter, the court noted that if you have proportional representation of the minority group, it is not necessarily automatic that you will lose a Section 2 case, because there may be some instances where you could draw additional minority districts even beyond those proportionality. It's not a safe harbor, even if you have it, but the lack of proportionality is not going to be enough to prove a violation either. Then there's some terminology that is not helping. I'm going to turn this way. So you we have packing. This is mostly applying to redistricting cases. Packing, that term is used. Cracking, stacking. Then you sometimes hear what are called crossover and coalition districts. And what this basically means is that if you, and there was a decision yesterday out of Virginia which involved this first issue, packing, they found that taking a district that was already effective for minority voters, congressional district in Virginia, that had already been electing the candidate of choice of minorities at 51% African American, the state of Commonwealth of Virginia, when they redrew that district in 2011, they bumped it up to 55%. And it was already effective as a 51% district for minority voters. And the court found that bumping it up to 55 was packing the district at a level higher than necessary for minorities to elect their preferred candidate, and was an overuse of race, because the reasons that the state did it in 2011 was because they wanted to comply with the preclearance provisions of the Voting Rights Act, which of course got struck down last year. So therefore, that Section 5, in the court's view, did not provide a compelling state interest anymore for the use of race in that manner, the predominant use of race. So that case has potentially, if it goes up to the Supreme Court, some possible huge ramifications, along with the Alabama case that the court has already taken and which will be argued on November 10th out of Alabama, an Alabama redistricting case that kind of raises that same issue as the Virginia case. A very dangerous case potentially for minority voters, and I'll only just pass a footnote here on this. The reason it's a potentially devastating case is because it could result in 5 justices on the Supreme Court saying that it's a challenge to Alabama's use of race in redistricting, and it could be, there might be 5 votes up there to say you can never use race as a factor in redistricting, or make it play such a minor role that it puts a lot of the minority districts at peril. So we'll have to see how that all turns out. The other issue is cracking. That's when you draw a district line and kind of dissect, or trisect in some cases, a group so that they can't be a majority in any one district. You basically fragment them or crack them. And when you draw lines in a redistricting plan, census data is you have it all by race. You can place the lines and exactly see, whether you're encompassing, bisecting, what you're doing with the minority community. And you have to, for the most part, look at that data in order to decide whether your plan is complying with the Voting Rights Act. So you have to look at the demographics, but you have to guard against cracking them in such a way that you split them so that they don't have a voice in either of the districts, say, if you're dividing them. And then stacking, you're drawing lines to overlap two districts, sometimes to force some incumbents to run against each other. That happens a lot of times for political reasons, but it can have racial implications if you're stacking a African-American candidate incumbent with a Anglo incumbent in a district that tilts in favor of the Anglo incumbent by its voting patterns. So that can be problematic. The last two issues are crossover and coalition districts. A crossover, and these differ. They oftentimes, many people, even in the voting rights community, kind of throw these terms out and say they're the same thing, but they really aren't. A crossover district is a district in which one minority group constitutes less than 50% of the population in that district, but nonetheless can join with other like-minded voters of a different race to elect their candidate of choice. Now, such districts can't be required under the Voting Rights Act, according to the Supreme Court, but a state is free to draw such districts if it wants to, or a county or a city or a school board. And then coalition districts, those are different because those are really refer to minority groups together being in coalition to elect a candidate of their choice. Say a state you can only draw a district that's 40% African American, but you also know that Latinos vote the same way African American voters vote in that region, and there is a Latino population there that when you join them together get over the 50% threshold of jingles that I mentioned earlier. That would be a coalition district, and you would have to show not only that you can get them over 50%, but you'd have to show that they're politically cohesive as well. And I know I'm going quickly because I want to get to our panelists, but I also want you to have a fairly good idea of what the lingo is here. So when is a group sufficiently large enough to be a majority in a single member district? Is it a majority of the voting age population, the citizen voting age population, a majority of the registered voters, a majority of the voters who actually turn out? Does it have to be a numerical majority? Are we talking about 50% plus one? Or are we talking about having an effective majority? Because oftentimes, even if the minority group is not 50%, let's assume you have a prison that happens to be in the district, or you have a large white population that doesn't vote for whatever reason. Well, even though minorities might not be over 50%, they could still be an effective majority in that district. Compactness is defined in a case, another one of mine, Lulac v. Perry out of Texas in 2006. And when the court looked at whether the minority group is compact or whether the district that you're drawing for minorities is compact, they referred to the minority population, not the shape of the districts drawn for minorities. When we talk about, if you go back and look at the slide on jingles that I showed earlier, you'll see it talks about whether the minority group is sufficiently large and geographically compact, not whether the hypothetical illustrative district you draw is compact or not. And there's no, of course, constitutional requirement for compactness anyway. And how do we measure racially polarized voting? How do you decide, these are issues that come up. Who's the candidate of choice? Do you look at just black versus white elections? Are elections in which only white candidates have participated? Can they be used to determine racially polarized voting? What kind of statistical analysis should be used? There's ecological regression typically used by statisticians to analyze voting patterns in the cases. There's also something called ecological inference. These are all statistical tests that expert witnesses hired in these cases perform routinely. And when, even if you have racially polarized voting, does it become polarized enough to be legally significant? And then what constitutes rough proportionality in a case? Do you look at a region of the state or do you look at the entire statewide? When we brought Johnson versus DeGrande, one of the mistakes we made in the Justice Department was in our complaint, we said that Latinos in South Florida do not have the ability to elect a candidate of their choice in a sufficient number of districts. And that was because we could create additional Cuban districts, in that case, down in South Florida. But it turned out that they already had proportional representation in that region in South Florida, but we were arguing for an additional district, and the Supreme Court said, well, yeah, but the way that your complaint was worded, you can't look at Latinos in Orlando and other parts of the state and say Latinos are 20% of the population statewide, so they should have 20% of the districts. You targeted your lack of proportionality to South Florida, so that's what you're stuck with. So careful in your drafting, I guess, was a lesson learned there. Bartlett v. Strickland, I already covered this. This was a crossover district case, kind of the most recent Supreme Court redistricting decision until the one from Alabama. And this is basically says that you can't require people, states and local governments, to create these crossover districts where the minorities can't get over 50%. Even if white voters, they get a sufficient number of white voters to vote with them to elect a candidate of their choice. You can't force that under Section 2, but the states are free to draw such districts if they choose. So the gerrymander, you couldn't have a voting rights conference without talking about gerrymandering, not named after me. It was a long time ago when Eldridge Gary, as it turns out, not Jerry, but it was Eldridge Gary, the governor of Massachusetts, signed a state Senate plan there that created that district, actually, running from Salisbury County on the top around through what is now 495 in Massachusetts, all the way down to Lynn and Chelsea, outside of Boston, and that was called the gerrymander or gerrymander, and it was used to describe district lines that were drawn to advantage or disadvantage a political party or a candidate. Now, there were also the case I mentioned about Virginia where they said that race had played too much of a role. We call those the Shelby-Reno line of cases, and basically it was a series of cases that came out in the 1990s that basically kind of changed the rules on redistricting. Everybody thought in 2001 that, 1991 and 1992 when people were drawing districts, that if you could create a new majority-minority district, and the legislature had failed to do so, but you could show that it could be done, that pretty much that plan was going to eventually fall under the Voting Rights Act. And the Supreme Court came along and said, look, race can continue to be used as a factor in redistricting, and it can even be the predominant factor so long as it doesn't subordinate traditional redistricting principles that are non-racial. So things like respect for political subdivisions and those kind of, respect for county boundaries or city boundaries, or sometimes protecting incumbents. Those can be traditional redistricting principles. Compactness can be a traditional redistricting principle. And in a series of cases that extended over about a 10-year period, when you let race be the predominant factor in drawing lines, then the burden will often shift to the state to have to show a compelling state interest that's narrowly tailored. And for the most part in the 90s, all the states lost those cases. They had drawn districts predominantly using race, as Justice O'Connor, who offered many of those opinions, noted, to the use of race for its own sake or as a proxy for accomplishing some other goals. So when that happens, the burden shifts to the state and strict scrutiny applies, and it can often be fatal, which it was in many of those cases. So now when people draw districts, there's not as much open acknowledgement that they're drawing minority districts just for the sake of drawing minority districts or to comply with the Voting Rights Act. They try to mask the language so that it doesn't look like race is being used for its own sake, that they're simply respecting the minority community's ability to elect a candidate of their choice. And so far, the Supreme Court has allowed and assumed that compliance with Section 2 of the Voting Rights Act is a compelling state interest. So we'll find out, maybe in the Alabama case that's pending, whether that holds true. I wanted to touch on intent cases. I said that Section 2 was a results test. You didn't have to prove intent. But oftentimes, these days, especially in the post-Shelby era, we do try to prove intent. And the reason we try to prove intent is because we want to put under preclearance many of the jurisdictions that previously were subject to the preclearance requirements and no longer are, but have been engaged in what we consider to be purposeful discrimination post-Shelby. So Texas being Exhibit A for this, we've argued in the redistricting cases and in the photo ID case there that they enacted their laws with racially discriminatory intent. And if you establish racially discriminatory intent, that qualifies you to ask the court to designate that state or political subdivision, if you sued a political subdivision, for preclearance requirements going forward, at least with redistricting or photo ID laws, or maybe even more generally. And I've listed here the factors that you typically have to prove, or that are relevant, actually. You don't have to prove all of these factors, but these are the ones that have been deemed relevant in proving intent cases. And it comes out of a case called Village of Arlington Heights versus Metropolitan Housing Corporation, 429 U.S., somewhere in there, 1977. Great case because it really gives a roadmap for how to prove intent. And so these are some of the ways that the factors that courts have considered in doing this. Note that one of them is discriminatory impact. You have to show at least there's a discriminatory effect, which is a good starting point for deciding whether or not there's intent. And these are all kind of things that, historical background of a state. Well, if a state is engaged in a long history of discrimination, it doesn't take a leap of faith to say, hey, maybe they did it again. I mean, Texas is again, Exhibit A for this. Texas has never had a redistricting plan survive court attack since the 1960s, ever. They lost in the 60s. They lost in White v. Register in 73. In the 80s, they lost in a case called Upham versus Seaman. In the 90s, they lost Balderas. They ended up losing Lulac v. Perry later in the decade in 2000. So, I mean, you've got a series of decisions over time. And so that's relevant in deciding, hey, is the state likely to have engaged in racial discrimination again? Yeah, I think they have that propensity. Political gerrymandering. All I'm going to say about this is that there was a case that we brought to the Supreme Court called Veith versus Jubilator. We lost 5-4. I'm really good at getting 5-4 votes, unfortunately on the for side. But Justice Kennedy, in his concurring opinion, saying that political gerrymandering cases were justiciable, but they just haven't been justiced yet, says that the First Amendment may be the most relevant constitutional provision in future cases seeking to declare partisan gerrymandering unconstitutional. The First Amendment. So a bunch of people got together in 2011 and said, well, let's bring a First Amendment case and see what happens. Well, the first thing that often happens when judges want to rule against you is they rephrase your case to say, well, this is what this case is really about. So in an Illinois case brought by the Republicans, the three-judge court rephrased their partisan gerrymandering claim to say, so because the redistricting plan means that Republican voters in some districts are less likely to be successful in electing their preferred candidate, these voters' First Amendment rights of expression and association have been violated. So they rephrased their test. And then they say, but the court finds no connection between the plaintiff's right to elect their preferred candidate and their freedom of political expression. And get this, under the redistricting plan, plaintiffs remain free to run for office, express their political views, endorse and campaign for their favorite candidates, vote, or otherwise influence the political process through their expression. The whole point of the case is they aren't able to influence the political process through their expression because the district's lines have been drawn to particularly and with intent to disadvantage them. So if the test is that you remain free to run for office or that the political party can still let their people vote, I mean, what kind of a test is that? That bar is so high nobody will ever get over it, and the court knows that full well. So the League of Women Voters came along and said, well, let's go ahead and we'll try again. Let's bring a separate case called League of Women Voters of Illinois versus Quinn. Now they thought, well, they've already had the benefit of the Rodogno decision, so they tried to frame their challenge differently, and they said, well, we think that you're doing viewpoint-based redistricting to control our electoral speech or the activities of our members. And by seeking to draw districts to achieve a partisan result, what you're really doing is countering League of Women Voters members' efforts to express their views because it tilts districts so much one way or the other politically that the voters left in the districts don't really have a political voice. And they cited Citizens United as one example of how the court has been receptive to those kinds of issues. And the Arizona case, which negated public financing, among others. So, but three-judge court said the challenged law, however, they rejected the claim. A challenge law must restrict some form of political expression, and the redistricting plan imposes no such restriction here, basically applying the same analysis. So where we're left with is the political gerrymandering claims are still justiciable, but as I said earlier, they haven't been justicied yet, and I think that it's so far none of the cases have worked. All these cases were appealed to the Supreme Court, and they simply summarily affirmed each one. You'll hear today about Crawford versus Marion County. I'm drawing to a close here. This was the Indiana voter ID case. Indiana adopted a photo ID law to combat voter fraud, voter impersonation fraud in Indiana. And I can tell you that there are 0 cases of voter impersonation fraud in Indiana in the history of the state. And yet the Supreme Court said that they could still rely on that because that was a legitimate state interest for the state to rely upon, and the state had an interest in protecting the integrity of its elections. Now, it does not stand for the proposition, however, that all photo ID laws are unconstitutional. And in fact, in Texas, we have what we call a Crawford claim, and there's one in the Wisconsin case that's now was just decided recently by the Seventh Circuit. But it was a fairly narrow claim in the Indiana case. It was not a Voting Rights Act claim, and it was simply an argument that it was an unconstitutional equal protection burden on its face to impose on voters, a non-racial equal protection claim. And it was a facial challenge. And in the Texas case, we're making a different argument. We're doing more of an as-applied type challenge. And there was no Voting Rights Act claim in the Indiana case, and there was no poll tax claim. Now, I say make those points because, and you all probably remember hearing about this in law school, if you can remember that far back, at least I can sometimes remember, but it was that bad cases make bad law. And this was a bad case to take to the Supreme Court because they brought it up to the Supreme Court in a facial challenge even before the law had been implemented. So, of course, there was nobody who they could show were actually denied the right to vote as a result of the photo ID law, which, of course, the Supreme Court zoned in on. So there are some pending Texas voter ID cases now. The V.C. Lulac versus Perry case is our case, Mr. Dunn and myself. It's a Section 2 case. It's an intentional discrimination case, 14th and 15th Amendment. It's a First Amendment case, and it's a 24th Amendment case, poll tax, because you have to pay. They say they'll give you the free ID, but in order to get the free ID, you have to buy documents in order to get the free ID, so we say that's a poll tax. The Justice Department eventually filed a lawsuit, and then that suit was consolidated with ours. They also allege intent and a violation of the Voting Rights Act. They don't make these other claims, poll tax and others that we've made. And we just went to trial, and we expect a decision any day. There were also lawsuits filed by the League of Young Voters, Texas NAACP, often making some of the same claims that we did. Again, all those have now been consolidated. But the last bullet, all complaints seek relief under Section 3C of the Voting Rights Act, which is we all want to bring Texas back under preclearance regime. So we all have that in our complaints. So let me stop there. I know I've gone on probably longer than I needed to, but I wanted you to have at least an understanding before we bring panelists up here and they start throwing terms around, because these are things that we do every day, and they're not, and you do things that you know a lot about that I know nothing about, so I wouldn't want you to start talking about your stuff without my at least knowing what the jargon is. So let's bring up everybody on the panel, actually. So Neil, Chad, and Nancy and Fernita, if you could come up and sit with me, because we are being recorded. We want to get you all in here, and I think we have that. We will take a break at some point after probably another hour or so, or 45 minutes. Bring your name tag if you have one. I think they're... Yes. So mostly I thought we could talk a little bit about some of the post-Shelby County issues first. What has happened since the Supreme Court gutted Section 5 of the Voting Rights Act, what some of the issues are that are now pending in litigation, what some special considerations are involving voter ID cases. And I also want you to feel free that if you want to ask a question, don't wait till the end. Just raise your hand and I'll spot you and we'll have a conversation rather than just lecturing to you. So, Fernita, can you start us out and tell us what the post-Shelby world looks like and what you're seeing?
So there's a lot going on, which is probably the understatement of the year. So we have, as you mentioned, the Texas voter ID trial just happened. We also have a litigation over Ohio cutting their early voting. And then there's also the North Carolina election bill, which has so many provisions it would take me 15 minutes to list them all. And then there's a litigation over the Wisconsin voter identification law. So in just the last couple of weeks, we've had a lot of decisions come down resolving some of these issues. And in particular, one thing I want to talk about is how this litigation really does help shed light on the scope of Section 2 outside of the vote dilution context, which is something that we didn't really have much case law on before. So in particular, and I know you mentioned Section 2, but just to reiterate it, forbids any standard practice or procedure which results in a denial or abridgment of the right to vote on the basis of race. And so it's an effects test, although you can also establish a Section 2 violation by showing either intent or effect. Now, until recently, most of the Section 2 case law dealt with redistricting or the methods by which elected officials were voted on for office. But post-Shelby County, many voting rights advocates, Jerry and others, have used Section 2 in order to challenge some of the restrictive voting laws passed in the wake of the decision. So, for example, you have the lower court decision in Frank versus Walker, which is the Wisconsin voter identification law, where the court found that the plaintiffs had a very good chance of prevailing on their Section 2 claim. And then recently, the Fourth Circuit decision in the North Carolina case, where they also found that the Section 2 claim was meritorious. And finally, the Sixth Circuit was also viewed the Section 2 claim very favorably. Now, one thing that is important to understand is that the court in each of these cases viewed the Section claim very broadly. So the Fourth Circuit outlined it as a two-part test. The first part, does the law impose a disproportionate burden on a protected class? The second part, is the burden at least partially tied to historical/societal factors that lead or have led to discrimination against the protected class? So the reason this test is important is because the Fourth Circuit used it to find that the elimination of same-day voter registration and also the ban on out-of-precinct ballots, that those two things had a disproportionate impact on minorities because African Americans in particular there are a higher percentage of African Americans that live in poverty in North Carolina, that African Americans were more likely to relocate in the state and therefore were impacted by the ban on out-of-precinct ballots. And also, they had a higher percentage of African Americans that had no access to a vehicle. Now, if you can contrast this with the Seventh Circuit opinion, reversing the preliminary injunction that the Wisconsin lower courts had granted with respect to their voter identification law, you really do see the two different views of Section 2. So Judge Easterbrook, who wrote for the majority in the Seventh Circuit case, basically put forward a very narrow test for resolving these claims under Section 2. So he rejected the second prong of the Fourth Circuit test, which, if you'll recall, relied on sort of general societal discrimination as a factor in determining whether there's a Section 2 violation. He says that this has to be discrimination that is committed by the state. The court, the Seventh Circuit, also observed that whites are more likely than blacks in Milwaukee to have a driver's license, but they basically dismissed this evidence because black voter registration rates are higher. And everyone, and this is a quote because I just found it so remarkable, everyone has the same opportunity to get a qualifying voter ID in Wisconsin, right? So he really did sort of dismiss many of the factors that the Fourth and Sixth Circuits felt were relevant in determining whether or not Section 2 was violated. He also ignored past discrimination, which was also very important to the Fourth and Sixth Circuits. So unlike the Seventh Circuit, these other courts really did look at the totality of the circumstances as demanded by the actual statute in determining whether there's a Section 2 violation. So because of this, a wide variety of metrics were relevant to determining whether or not the statute was violated. So the lower court in Wisconsin, for example, it mattered to the court that the effect of the law would not only affect voters who did not have the requisite ID, but also the voters who wouldn't have gotten an ID but for the law. The court thought that this was relevant in determining whether or not Section 2 was violated. Likewise, the Fourth Circuit considered the effects of all of the restrictions in their entirety in the bill in determining whether or not a particular aspect of the law violated Section 2. Also, the Sixth Circuit rejected the idea that there's no Section 2 violation where only a small percentage of minorities are affected by the law. So here you have courts being more willing to take a broad view of the restrictions at issue in determining whether or not a Section 2 violation exists. Now, there are some concerns about this, right? In reading the opinions, I was both elated, excited, and terrified. And let me explain my terror. Terrified because there are already questions about the constitutionality of Section 2 because it does require effect and it doesn't require intent. So opponents of Section 2 are already laying the groundwork by arguing that Section 2 has to be interpreted to require discriminatory intent in order to be constitutional because Congress cannot outlaw conduct broader than that which the Constitution prohibits. So there's some concern that by reading Section 2 broadly, this could potentially put Section 2 on the chopping block of the same court that invalidated Section 5 in Shelby County. Now, one of the reasons that this may be of some concern is because the Fourth and the Sixth Circuits also looked at retrogression. Retrogression was the standard that courts use in Section 5 cases to determine whether minorities are worse off under the new proposed change than they were under the old rule. If minorities are worse off, then the Department of Justice did not have to pre-clear the particular change. So in the Section 2 cases, courts are looking at retrogression and making a determination as to whether Section 2 is violated. Now, the problem with this is that in a case called Reno versus Bossier Parish, the Supreme Court held that the issue of discriminatory purpose and the issue of retrogression should be treated differently for purposes of determining whether or not Section 5 is violated. So in the court's view, the standard for Section 5 is retrogression. So you can have a plan that has discriminatory purpose, but it's non-retrogressive. Under Reno versus Bossier Parish, the Department of Justice had to pre-clear that plan. Congress, when it amended the Voting Rights Act, Section 5 in 2006, rejected this interpretation of the statute. So under Congress's approach prior to Shelby County, a plan that was discriminatory but non-retrogressive did not have to be pre-cleared. Now, notably, Shelby County pointed to this as evidence that Section 5 intruded on state sovereignty, right? Congress overturned Reno versus Bossier Parish. They expanded the scope of Section 5, i.e. now Section 5 is even more intrusive on state sovereignty, raising federalism concerns. So the significance of this is that when these cases go up to the Supreme Court, if and when they do, the court might be less amenable to a reading of Section 2 that includes a retrogression analysis that had been the case under Section 5, because then all of a sudden Section 2 starts to look like a replacement for Section 5, as opposed to Congress passing a new coverage formula to bail certain jurisdictions in. So that's my terror. That these cases present an opportunity for Section 2 to be invalidated. But the reality is that there's not much you can do but fight on. So I really do think the good outweigh the bad in these cases because we're getting some sense of how to use Section 2 outside of the vote dilution context, which arguably the text of the statute anticipated, even though in the last few decades that really has been the focus. Okay, I'll stop there.
Okay. And that's helpful, actually, because one of the things that you probably have heard about is the fact that Congress has before it a Voting Rights Act authorization bill that was introduced earlier this year. And it's intended to kind of bring back some of the jurisdictions into the preclearance. Now, there are many who feel that the legislation, stands no chance of getting even through the House or even a hearing in the House. That remains to be seen, and people are working very hard to get it enacted. But the fact is that all these Section 2 cases that are out there right now litigating, and they're the high-profile cases, the North Carolina, Texas photo ID, and redistricting cases, those are pretty high-profile cases. Well, if the civil rights groups who really were devastated by the Supreme Court's decision in Shelby are now bringing all these Section 2 cases, and the courts are ruling, as Judge Easterbrook did in Wisconsin, for example, that you can't win these cases, well, doesn't that show that Congress does need to enact the legislation? I mean, one of the reasons for bringing these cases is to certainly secure relief for the voters in the states, but it also, I think, is going to be building an important track record for eventually Congress, when it finally stops deadlocking on issues of importance to average Americans, takes a look at the Voting Rights Act legislation. And so, Chad, I want to follow up with you because one of the things for many of us, and I think Neil and I probably share this view, many of us, when we came into work on voting rights cases, we didn't work on these like photo ID cases. And I mean, the issues were real basic, and they were about denial of people's right to vote, right? And we did a lot of work in the 60s and 70s and the early 80s to kind of bring around and get all those denial cases done. And, and eventually minority voters, primarily in the Deep South, finally got to take their rightful place in the state legislatures and the city councils and the county commissions. And then what happened after that was that there was another generation of voting rights cases, and they were called the dilution cases. And I kind of gave you an example of, the Thornburg v. Jingles factors and how we look at those dilution cases, mostly in redistricting and challenges to at-large elections. Now what we see, as you pointed out, Bernita, is that we're back to the denial cases. And I just can't believe that after 41 years of doing voting rights cases, I am back to fighting vote suppression laws that deny people the right to register to vote on Election Day, that cut back on early voting sites, that impose photo ID requirements, knowing full well that those photo ID requirements are going to have not only an impact on a broad swath of the population, but are going to have a racial impact. And they're adopted because they are going to have a racial impact. I mean, these people in the Texas legislature and North Carolina legislature, they're not stupid. They study and figure out how's this law going to work and who's it going to disadvantage. And when it disadvantages people who don't look like them, or who don't vote for their particular political party, that's when they pass these laws. So I think we're in this kind of Neanderthal stage again of back into the denial. And Florida too, right? You're going to hear about Florida in a few minutes. So, Chad, what I want you to talk about the Texas cases and tell us a little bit about how it came to be that these voting rights cases, Section 2 in particular, used now to challenge these denial cases, and you see kind of conflicting interpretations of Section 2 in the North Carolina Fourth Circuit versus the Seventh Circuit Wisconsin case. Maybe these cases should be brought under, maybe these cases have the best chance of succeeding under provisions that don't involve race.
Well, I don't think there's any question that that's true in Texas.
Turn that a little bit toward you, but you don't need to speak very close to it.
Which, of course, is unfortunate that we're at the stage that we have to find other ways to deal with intentional voting discrimination against minorities by using non-racial claims. But unfortunately, a majority, I think, of the judges at the Fifth Circuit governing Texas, Louisiana, Mississippi, have shown a great hostility to voting discrimination cases based upon race. So one of the things that we tried to do, Jerry and I tried to do in the Texas ID case, was bring the racial discrimination claims, but also try to bring behind them what we refer to as race-neutral claims as a way to see if we can open the door, at least in the Fifth Circuit, to some type of procedure that can be effective to deal with these, to deal with some of these new measures. So I was going to talk about Texas briefly. One of the things that's unique about Texas, I'll contrast it with North Carolina. So when Shelby County came down and states no longer had to get preclearance, North Carolina released a new bill. It had already been working on a photo ID bill. When Shelby County was issued, members of the state legislature said, well, great, we can do the full bill now. And this laundry list of vote suppression measures was then announced and then quickly passed by the legislature. That's being challenged now. Texas has taken a more incremental approach, but equally devastating in my view. They have passed measures for making most activities for example, in voter registration are felony offenses now. So if an 18-year-old student went to his high school or her high school and passed out voter registration cards to other vote-eligible students, had them filled in, and then collected them and dropped those in the mail, or took them down to the voter registration office, which we call the tax office in Texas, which is a legacy of the poll tax. You used to have to pay your poll tax when you registered. That's a felony now for a student to do that. Without first getting registered and trained, they would have to get registered and trained in every potential county where they might accept an application. It's a criminal offense for somebody from out of state to come into Texas and collect voter registration applications. So those measures passed. Of course, the redistricting measures passed. You heard about photo ID. Those measures passed. But I think the thing that gets lost, at least it does in my state, about the impact of Shelby County is it's been cataclysmic. And it's been that way on things that don't make the newspaper. Everybody's concerned about photo ID and redistricting. They're incredibly important. I work on those, so I don't undermine the importance of those cases. But we have, school boards, local county commissioners, local county government that is now systematically being whitewashed in Texas because Shelby County permits it. So I'll give a few examples. There is a school district in Beaumont, Texas, that is majority African American student population. It's right at majority African American voting age population, but the voting population there doesn't, as we call it, perform very well. It doesn't turn out as well as the Anglo population does. This district, as a result of 20 years worth of federal court orders, had single-member districts, and those single-member districts would elect at least 4 African Americans to run what has been a majority black school board for 20-something years. A group of Anglos in the community got a citizen initiative passed by the school district, forcing the district to go to 5 single-member districts and 2 at-large districts, which would result in 4 Anglos controlling the school district. That was ultimately stopped as a result of Section 5. The Department of Justice rightfully objected to this change. And the minute that Shelby County came down, a Texas state court ruled that now it can go forward. We had been successful at getting a state court injunction to stop that. And then ultimately the state took over the school district and appointed a new board that is not majority African American. And a number of people have been discharged now from the school district who are African American teachers, police officers, and there's a lot of allegations that it's essentially trying to clean out the district and replace it with white personnel. So that's one example. Another example that hasn't gotten any attention is in Galveston, Texas, just south of Houston on the coast. They have justices of the peace, which are sort of the small claims court in Texas, and then constables, which are law enforcement officers. They had 8 districts. And the Commissioner's Court, after the 2010 election, a number of Anglos had gained election, they tried to whitewash the county and eliminate a number of the black and Latino JP and constable districts. It was objected to by the Department of Justice. It was stopped. Shelby County came down. Within a few days, the district readopted the same policy had been found to be discriminatory. It's in effect now. There's an election about to be run under the unfortunate map in about a month. We tried a case back in January to stop it under Section 2 and other provisions, and we haven't received a ruling yet. Then there's another measure that hasn't yet taken effect and isn't yet in litigation, but I suspect will be. There's the city of Pasadena. Some of you might remember the Urban Cowboy film. That town was made famous in that film from the 70s. But in any event, Pasadena, southeast of Houston, has been majority Latino for, I would guess, at least 2 decades. That city council has never been majority Latino or majority Latino candidate of choice. But they're concerned that it will be the majority, and so they have elected to go to what's called a split system, where they have a number of single-member districts and then a number of at-large districts, which will have the result of extending the Anglo dominance on the board for some time. The Commissioner's Court, the City Council. So, and there's other examples throughout the state, and one of the things that I think gets lost in the post-Shelby County world is that so many of these issues are on the back burner because redistricting is typically held every 10 years. There are, for example, a number of districts in Texas that are famous, and some famous Americans have been elected to these districts that have changed the world for the better. Barbara Jordan, for example, that came from districts created under the Voting Rights Act that arguably don't meet the voting rights threshold that Jerry explained of 50%. but we're protected under Section 5. Those districts are sort of safer now because nobody's doing redistricting, but in 6 years when that process starts and there's no rules, if there are no rules and some of these cases don't come out better than I fear they might, we're going to see a dramatic step back in the rights of Americans, and particularly Texans from my state, to exercise the right to vote. So I think it's terribly important that we focus on the Section 2 claims and focus on the constitutional claims, but I think we also need to start thinking, if conservative majorities continue to have the Supreme Court, continue to have important circuits like the Fifth Circuit, which covers so much of the South, we've got to find additional ways to try to pound through some of these barriers. And so hopefully that answers the question.
Yeah, I think it does. One of the things that you should be aware of is that if in this voting field, and Chad's focus on these smaller jurisdictions is really helpful to illustrate this point. Oftentimes, you don't have to, if you're with a law firm or if you are a solo practitioner, you don't have to drop everything you're doing for a year and a half, and as we had to do in the voter ID case, for example, to do some of these smaller cases. Sometimes, and I'll give you an example out of Jasper, Texas recently. Jasper, Texas is a city that's about 50% African American, 50% white. It's a very racially infamous town. They dragged James Byrd to his death there. Two white supremacists did about 15 years ago. And it's still a hotbed of racial tension. And blacks got control of the city council, 3 out of 5 districts. They were immediately subject to a recall election by the white community, which then recalled 2 of the African Americans, and then they replaced them with 2 whites. Now, the black community is pretty tight, pretty organized, but they couldn't overcome the strong turnout among the whites in the recall election. However, they might, in the next election, run sufficient number of black candidates to actually win back control. So the white majority on the city council announced that it was now going to annex 2 huge white neighborhoods on the edge of town that were outside the city limits, so that all these white voters would now be part of the electorate for the city council to guard against the eventual, perhaps, black retakeover of the city council. And when we heard about this, we analyzed what the demographics of this, and it took us a half a day to do that. We looked at the census data, and we looked at where the neighborhoods were, and we called a few people, and then we wrote a letter on behalf of some of the black community leaders saying that if you do this, you likely will violate Section 2 because annexing this seems to be racially driven, and it will have a discriminatory result. And they backed off. Just a simple letter. So you can do a lot of things short of dropping everything and litigating and spending $250,000, as Chad and I had to do to litigate the Texas photo ID case, and still have an impact, particularly on these places, some of the local places. Neil, you've heard a couple remarks so far. What is your take on this?
Well, I would like to follow up on the point you made a moment ago, Jerry, about 30, 40 years ago we were doing denial cases, and denial cases are back. Pardon my voice. I've had a cold for a second. I hope you can hear me, but I don't normally talk like whatever I'm talking like. If the states had been adopting these laws 40 years ago, my view of we would have won those, and we would have won them pretty easily. And let me explain. There were denial cases, and the courts were used to denial cases. They've been looking at them through the 60s. And so they had this sense of incredulity when people came in with restrictive laws. Courts were open to saying, we don't believe you. There's a really good example, the Dunn versus Bloomstein, which struck down the durational residency requirements that Tennessee had, other states had them, where you had to live in the state for a year before you could vote. And there's an opinion written by, old liberals, but I don't think that really makes much difference. The Tennessee defended this durational residency requirement with 2 arguments. I mean, their compelling state interest, as they focused them, were we need to protect the purity of the ballot box, which is what we now say, And they also had this idea of we wanted to have knowledgeable voters, so you need to live in Tennessee before you can learn enough about Tennessee politics. And one of their arguments about the purity of the ballot box was, we fear that people will move into Tennessee just to vote, and then they will leave. They call it colonization, fraud by colonization. Now, Justice Marshall had been around the block a couple of times, and he has an opening line in there that says, purity of the ballot box sounds like a compelling state interest or a really formidable interest. And then he went on to just destroy the state's arguments, not necessarily with facts. It was just, because it was a facial challenge. But he just essentially said, you don't pass the laugh test. That's about as close as justice will ever say to that. You sounds like a formidable interest. So they struck it down, and they struck it down by saying, you don't need this. You've got voter registration laws now that you didn't have 50 years ago. And you're blocking legitimate citizens from voting, and we just don't buy it. Now, that standard, they didn't really write a standard in Dunn versus Bloomstein. It was just a common sense analysis. And what happened after that was we essentially got a bait and switch. The Supreme Court changed the rules for challenging election laws. They didn't say they overruled Dunn or anything like that. But they adopted this standard. They adopted it out of two cases, Anderson versus Celebrezzi and Burdick versus Takushi. Anderson was a case about how do you get on the ballot, how many signatures do you need and when. Burdick was a case about we want to vote for a write-in candidate and we're barred from voting for the write-in candidate. They weren't about vote denial at all. So the standard, I'll just read it quickly if I can, from Burdick. Petitioner assumes erroneous the law that imposes any burden on the right to vote must be subject to scrutiny. This court's cases have applied a more flexible standard. The court, considering a state election law challenge, must weigh the character and magnitude of the asserted injury to the First and 14th Amendments that the plaintiff seeks to vindicate against the precise interest put forward by the state as justification for the burdens imposed by the rule. Taking into the consideration the extent of those interests make it necessary to burden the plaintiff's rights. Now, you could read that slower, but it won't make any more sense to you as something to judge a constitutional issue by. But that's what these Texas lawyers are facing. That's their standard. Now, what is missing from this standard? What's missing is a proportionality test. If you have a really important interest, like fraud, and you have a device that will protect one case of fraud, but will disfranchise 1 million voters, nothing in this test will help you. There's a total absence of the efficacy of the rule and how many people it hurts. That's what is needed to have any realistic chance of winning a routine denial case or any election law case. Now, there's a little bit of glimmer in that some members of the court have understood this. In the Crawford case, there was some talk of we don't know how many people are affected. And that's an impact case, or we will strike it down maybe if you show this really hurts a lot of people. There's another case in which at least that also shows some concern about that. There's a stay case, Purcell versus Gonzalez, where the court was lifting a stay in a proof of citizenship case out of Arizona. And at least Stevens, in concurring at the end, said, well, when this goes through a trial, maybe the impact of the law and how many it affects will become known, and that should be a factor. Now, Stevens isn't there. You need 4 more votes. But that is really one of the problems of winning any election law case outside the Section 2 area. When you try to win it on the Constitution, we're stuck with this gibberish standard. And they didn't say that. They didn't tell us we're changing the rules and we're taking things from where it might make sense. When you're making judgments of how many signatures and when do you have to get on a ballot, that's not denying anybody the right to vote. When you're making a decision about when is it time to get on a write-in candidate on the ballot, you're not really denying anybody the right to vote. It's just like keeping a candidate off the ballot. There are rules that can sort of make sense mathematically or calendar-wise. But to then say, oh yeah, we're going to apply that to vote denial without any measurement of the impact, I mean, the Supreme Court has really changed the rules. And one of the related thing on this is one of the difficulties I think in the photo ID cases is the Supreme Court has never applied an economic standard to the right to vote. When it struck down the poll tax, it didn't say it's not fair to tax people to vote. It didn't say that any kind of wealth discrimination is something we are concerned about. All it said was that paying money has no relationship to the right to vote. It's just an irrelevant factor. So we'll strike it down for that. It fails strict scrutiny even because it's not logical. So because of that, when people argue in the photo ID cases that it costs $30 to get a birth certificate or it takes me 6 months or whatever it is, the economic impact is not something that the Supreme Court has ever recognized in a vote denial case.
And, you know, that's interesting because on the economic impact part, that really goes to that second factor that Vernita was talking about the kind of historical discrimination that has existed or societal, exists today, factors. You can look at socioeconomic conditions of the community being impacted, and they're generally the poor and people with less means in terms of vehicle access, financial access, oftentimes other factors that just show that they are a disadvantaged community. And then there's obviously a link between poverty status and race or ethnicity in many communities, and yet the court has not really starting a long time ago with Rodriguez, hasn't really allowed us to pursue that stream of thought. Your comments reminded me of a couple of things from Texas as I was thinking about the Burdick balancing test and everything. So and I'm going to go to Nancy in a minute, but just in terms of the Texas case, first of all, understand, and I think you do, that now we all have the burden of proof, post-Shelby. Before Shelby, jurisdictions with a long history of discrimination had to overcome a presumption that the law that they had passed was discriminatory, and so they had the burden to establish the absence of discriminatory purpose or effect. So now the burden is on us. So in Texas, for example, we made a conscious decision, Chad Dunn and I and our other legal team members, that, okay, so if we're going to bring a voting rights case, how are we going to prove that this law has a racial impact? So the way it's done, and this is what led us to believe we need to do something other than the Voting Rights Act claim, was you take the voter registration database in Texas, which has millions and millions of people on it. You then take the driver's license database from Texas, which has millions and millions of data on it. You take the database for the license to carry a firearm in Texas, which is also one of the IDs you can use to vote. And then we looked at the U.S. passport database, which has millions of people. And we then developed an algorithm, which the simple explanation is you do sweeps of those databases. You put the databases together and you do sweeps to see how many people on the voter registration database in Texas lack one or more of those IDs. And if there's a match, you then can rate them. Strong match, basically same name, same date of birth, same last 4 digits, SSN. So you can do all that. But can you imagine how, first of all, costly this is to do? And you have to have, obviously, experts. And the process can be very error-ridden because the data are also error-ridden, particularly the driver's license database in Texas. So you do that, and we found, and Texas actually did this at the time they were getting ready to pass the photo ID law. And if you can either believe this or not believe it, but whether you believe it or not believe it, it's still damning, which is what I love when it's a double-edged sword like that. But Texas actually testified that the Secretary of State had run the database analysis across these databases and found that there were 800,000 people in Texas who were registered to vote but who lacked all of the IDs that would be necessary to vote. But they never shared the information with the legislators who were passing it. even though state legislators like Wendy Davis and others were saying, do we know how many people lack the ID? And they were saying, and the sponsor of the bill would say, I'm not advised. Well, do we know whether it is blacks and Latinos who lack the ID? I'm not advised. That's all he would say. He wasn't advised about anything, really, when you think about it, other than his own racially discriminatory intent. So 2 cases of voter impersonation in Texas in the last 15 years. One was a father and son situation. The other were 2 brothers, where the brother was out of town, so the other brother went and voted for him. Those are the 2 examples. During that 14-year period, 32 million people have voted in Texas. 2 examples of voter impersonation fraud, and yet that was the main justification, at least for the most part. It kept shifting over time as Texas realized that that wasn't really a very good defense. So you have database issues, formidable proof. It cost us, we had to hire experts. The expert witnesses alone cost us $250,000. And we had to raise that money in order to fund this case and fund our own. We got no fees. We just did this really and tried to cover our expenses. Voter impersonation fraud is rare because think about how you would impersonate somebody to vote. If I'm trying to impersonate Neil Bradley to vote, first of all, I go to the polls. I'm there in front of 6 or 7 eyewitnesses, right? These are local government officials, poll officials, right? So I'm going to my local government to commit a felony in front of 5 eyewitnesses. And I have to hope that they don't know who I am. Because if they know who I am, they know I'm not Neil Bradley. I also have to hope they don't know Neil Bradley. Because if they know Neil Bradley, they know I'm not Neil Bradley. And the other thing is I have to hope he hasn't already voted that day by the time I get there. Because if I go to impersonate him and he's already voted, they're going to say, well, you already voted. And that's going to raise some suspicion. So that's why you don't have this kind of voter fraud taking place. It's just really a subterfuge or a pretext to accomplish the discrimination. So we say all that, and it sounds like we're just full of bad news today on an afternoon. But there is a lot of bad things happening. But there are people who are moving these issues forward. And somebody had mentioned we're facing some of these same issues in Florida. We have a Florida litigator here, Nancy Abudu, who's legal director at Florida ACLU. Nancy, what are your observations about where we're at today?
Thanks. Yeah, I've been trying to take notes so I don't forget because you all made reference to a lot of important issues. So one I'll mention is cost, which at first I wasn't going to say anything about because I didn't want to scare folks off from taking on these cases, but because you raised it, Section 2 cases are absolutely very expensive to bring. The evidence that you need in order to, meet your burden of proof is very extensive and expensive oftentimes to gather, especially when you're talking about going through the magnitude of documents that a lot of these databases include, when you're talking about the cost for experts on both sides of depositions and travel and presentation at trial. And so, again, it just underscores why Section 5 was so important and effective, because we were able to avoid a lot of that because the jurisdiction had the burden of proving that the law was not going to be discriminatory. And so now it's on folks like Jerry and Chad and others to find the money, quite frankly, to bring these cases with absolutely no guarantee that you're even going to recover your costs. The other thing I just wanted to mention is that, we talked a lot about Texas and Wisconsin and their voter ID, but when Shelby County was pending, Alabama and Mississippi also had photo IDs that they were trying to push forward. Alabama had already decided that it was going to wait and do kind of a soft implementation of its law, but Mississippi was ready to go and was just waiting for the Shelby County decision. And we tried very hard in the interim to get the data regarding the racial impact of the law, and unlike South Carolina, in which the state actually did the analysis themselves and then shared it with the public, and Texas, although forced, eventually provided the information, Mississippi was pretty obstinate in making it difficult for us to get that, which again to us showed that they probably, or at least they might have been aware of the racial disparities in terms of who their ID law would impact. I also wanted to mention in terms of Section 5, I always think in the Shelby County decision of Justice Ginsburg's dissent. And I believe, and this is a paraphrase, where she says, when you're in a rainstorm, you don't throw away your umbrella just because you're not getting wet anymore. And it's the same thing. I mean, to say that we don't need Section 5 anymore because it's been so effective really doesn't take into consideration that we've been effective because of Section 5. And so, again, I'm very concerned with what Congress is going to do in terms of the reauthorization or at least amending the Act. And if the amendments do indeed come into fruition, which jurisdictions are going to be covered? Of course, we would argue that a lot more than just 5 counties in Florida should be covered and have to go through the preclearance process because the whole country knows of all of the election problems that we have down here. I also wanted to underscore a point that Jerry made about sometimes it doesn't take a lot to get the jurisdiction to make a change. We had a situation here where out of the 67 counties, we found out during the primary election about 5 of them were not notifying voters who failed to sign their absentee ballot certificates. So they went through the process of requesting their absentee ballot, filling it out, and turning it in, but it was incomplete. Most of the counties were calling the voters back and letting them know that you need to cure this in order for your vote to be counted. But there were about 5 counties that weren't doing that extra step. And so for those folks, their votes never counted. And probably if they didn't take the initiative to make sure their vote counted, they were never informed. So the idea that they would then in the general election with the gubernatorial race that we're facing right now would go through the absentee ballot process again, which we've been encouraging people to do just in an effort to vote in some method, that their votes wouldn't count was very disturbing. So we sent a letter to those 5 supervisors of elections, and pretty much all of them have changed their policies. I mean, some we didn't even have to go through any back and forth, just wrote us back. We've looked at it. We agree with you all. We'll make the change. Hopefully it won't be a problem. So now we're in the monitoring phase. But that, again, was something where we just made a couple phone calls, did a little bit of investigation, wrote a letter, and hopefully that's been resolved. In terms of Wisconsin and photo ID, I just have to note that, the Seventh Circuit's decision not to stay the implementation of the state's photo ID law was not only, as many of us would believe, wrong, but in many ways the language could be viewed as offensive. I think there's a line in the court's opinion where they don't use the word lazy, but they might as well have used it for purposes of saying that, for these voters, they had 2 years since this law was passed to get their photo ID. If they haven't gotten it by now, it's their problem and their fault, not on the state. And for those voters who, had this law that was totally in flux, being challenged, and to say that despite this, unclear status of the law, you should have gone ahead and complied with it, is nonsensical in many ways. And so, again, just shows that the courts are not understanding, for whatever reason, the impact that these laws are going to have on communities. Neil mentioned the economics of voting, and I wanted to say that felon disfranchisement has been an area of voting rights where we've also been desperately trying to make some inroads. Right now, there has not been a successful Section 2 case in the felon disfranchisement arena. We've also brought poll tax and equal protection claims in the felon disfranchisement arena when it comes to the restoration process, and having to pay all of your fines, fees, and court costs in order to get your right to vote. And we always have said, or the ACLU, that victims definitely should get whatever restitution they're owed, but that should not be a barrier to being able to vote, because in essence, it is saying you are too poor to exercise the right to vote or to get your voting rights restored. The 11th Circuit has rejected that claim, but when we get into the novel legal arguments, I'd be very interested in hearing what the rest of the panel says, because I don't think that we should consider that issue dead, at least in the 11th Circuit. And then finally, I think we're going to talk a little bit about North Carolina, but that just goes back to what I was saying again in terms of, just the costs and all of the hurdles and obstacles that litigants have to go through, whereas Section 5, and maybe not so much in North Carolina's case, but in other situations, really would help to cut down on the cost and the time that it takes to challenge these laws.
Thank you, Nancy. One of the things that...
Sure. Could I say
Yeah,
about it?
absolutely.
Two quick things. One, I just want to give you some really bad news, and then I'll give you maybe a little good news. But this is a loaded sort of question, but there haven't been that many Section 2 claims in the last couple decades because we drew most of the districts we could. The ones that we're bringing now are sort of emerging districts. Where you get an increase in Hispanic or black population. So there haven't been a lot of cases. But I want to ask people to guess something for me. I don't want to know the year, but can you tell me what decade was the last time a Section 2 case prevailed on the merits in the 11th Circuit? Not a procedural victory, but on the merits, where the 11th Circuit affirmed a finding of vote dilution under Section 2. Yeah, Section 2 didn't exist in the 70s.
The 90s?
The 90s is right. It's been since 1993. It was a Dade County case. But it's been that long. It's that tough. But let me give you one piece of good news. There is a cheaply used statute that can help in voter registration. It helps mainly in fighting voter registration prior to litigation. But there's a section of the Civil Rights Act called Section 1971, and I'll get Jerry to send it to you, email. But that statute says you cannot be denied the right to vote for an act or omission in your voter registration that is not material to your qualifications. It doesn't involve race. It doesn't help with the photo ID because that's relevant to your qualifications of who you are, and same with citizenship. But you can use it if there's any problems with saying, well, you put your Social Security number in the wrong blanks, you didn't use a blue pen, or for whatever, you didn't put down, your address as a P.O. box, instead of a street address. It's very useful when you're being hassled or your people are being hassled by registration problems that are easily fixable. So anyway, and the 11th Circuit affirmed that statute. You can use it. It does exist. It's a 57 statute, 1957. It's almost not litigated at all. But the 11th Circuit said you can bring it. And the next time we tried to enforce it was in the 2004 election in Florida for president. And the judge said, even though the statute says you can't be denied the right to vote, the court said it didn't really protect the right to vote. It just protected the right to register. So I guess I had a caveat even to the good news.
One of the things about 1971 and trying to, back in 1957 when that law was passed, what you would find registrars of voters doing is rejecting black prospective voters' applications simply because they maybe left off like the zip code or something like that or whatever, some piece of information that was not otherwise relevant to their qualifications. And it was, uniformly used to knock people off from registering. And yet, and so while you may not see voting registrars systematically doing that anymore, you do see an alarming number of local election officials acting with basically utter disregard of the racial consequences of their actions. Harris County, Texas is, I think, a good example of this, which is where Houston is, the largest county in Texas. And you have a county elections administrator who's extremely partisan and who has really gone out of his way to make registering to vote harder for African Americans and Latinos. So even though you may not see the same kind of blatant, hostile, open discrimination that you saw in 1957, it's covered up better now and under the guise of, election administration effectiveness or something, but it, by and large, ends up in the same place. This goes to Neil's comment also about judges and how they view cases. Judges walk into the courtroom with a lot of presumptions. In the photo ID case, they walk in with a presumption, first of all, that everybody has an ID. I mean, everybody in this room probably has a photo ID that would qualify them to vote in Texas, which has got the strictest of all the photo ID laws. And we don't realize that there are many people who don't have an ID for one reason or another, for the most part because they don't need it. Or they have an ID, like a government-issued ID, for example, like a government employee ID or a student ID, and that's what they use as their ID. In Texas, those IDs don't qualify you to vote. So if you are a member of the Texas FBI, the state agency, the agency that you can't vote with your ID. If you are working for American Airlines in Dallas and you have the right to inspect planes for bombs, you need special ID to be able to access the security areas. You can't use that ID to vote in Texas. Students at all universities. And it's presumed that by a lot of people that, well, and this goes to the comment of, well, Nancy's comment, these people had 2 years to get the ID. Well, first of all, what we proved in Texas, and we brought people up live to testify to this, is that they had tried to get the ID. They tried, and they tried like 5 times going to the local county offices to get the ID, and they were unsuccessful because there was a hurdle placed in front of them each time. Sometimes it was because there was no record of their birth. So that all they had, because they were born to a midwife, say, 90 years ago. So you have a very elderly individual brought down to the office to get an ID, and they're not able to get one for one reason or another. And then they go home, and the local news picks up the story that this 90-year-old woman can't get an ID, and all of a sudden the state, in order to thwart success in the lawsuit, calls her up and says, look, we don't care what the law is, we'll get you an ID. So what they do is you have to produce a birth certificate, certified copy of your birth certificate in order to vote. If you are a Texan born in another state, you have to write to that other state and pay sometimes upwards of $65 to get a certified copy of your birth certificate. And if you want it faster, you got to pay more. So there's a fee involved. So she had tried to do that and was not able to do that because Tennessee did not have a record of her birth certificate, even though that's where she was born. So what did the state of Texas do? They actually, somebody in their driver's license office called DPS, went on the Census Bureau's website, looked back into Ancestor.com, and found that her name was listed in like the 1920s or 30s as having been a child of her parents. And so they said, oh, that's good enough. And they gave her the ID. I mean, that's how inconsistent, the law has.
Well, she happened to be white.
Well, she happened to be white.
An American went in with the same problem. They didn't get the Ancestor.com.
Wisconsin did something similar as well, right? That's why the Seventh Circuit issued that initial order, right? Because they started letting people get IDs without showing their birth certificate or having to pay the underlying fee.
Right.
But it was still a case-by-case basis,
Right,
and
exactly.
so arbitrariness was still part of the process.
Right, and one of the arguments we made in Texas was that we brought an equal protection claim, arguing not race-based equal protection claim, just that local administrators are administering the law differently by, in some cases, allowing people to vote without the ID. I mean, we had testimony from one county official who said, if somebody shows up and we know them, we let them vote. They don't have to show an ID. Whereas another county official said, no, we have an ID requirement. We're going to make everybody have it. We have a list of so there's a total inconsistency and unequal application, which is an equal protection problem. The other is that there's a lot of misunderstanding or misnomers about photo IDs that people have presumptions about. You always hear, and Texas argued this on the floor of the legislature, well, you need an ID to board an airplane. Well, first of all, a lot of poor people don't board airplanes. Just, I mean, that may be obvious, but secondly, you don't need a photo ID to board an airplane. I've done it. I did it. I intentionally left my wallet in my suitcase so I could go through with no ID. And you know what TSA said to me when I got there? Where's your ID? I said, oh, it's in my suitcase. I packed it accidentally. And they said, well, where are you going? I said, I'm going to San Antonio. I have a trial. I'm a lawyer. We have a trial coming up. And they said, oh, okay, go. So I went through. That's the additional screening. If you go on TSA's website, and of course I'm white. I realize that I'm white, and that probably has something to do with it. And I'm old.
And you're a lawyer?
I'm a lawyer, right? Yeah.
That should have gotten him extra scrutiny.
But the fact is that on TSA's website, they actually say you do not need a photo ID. So anyway, there's a lot of things. And that gets me to a point I want to come back to Pranita about. And you're a scholar, and you do research all the time. One of the things that we found as litigators in voting rights issues, and even just as lawyers in voting rights cases, not even litigation, is that there's a lot of information that's available out there that you can get on your own without having to pay for it, or documents through internet searches and other things. In public records, for example, we can do FOIA requests. I don't know what the law is in Florida about making FOIA requests, but in Texas, I mean, it's a really robust law, and it's an ability. I mean, we tried to use it actually in many cases to do free discovery from the defendants, even beyond the discovery deadline. When it's passed, we then did open records requests to local officials to say, well, tell us how many people showed up and were turned away and things like that. So, and they had to respond like within some really good short period of time, like a week or 10 days. So, but anyway, my question is, though, in your, is the information that scholars are writing about with respect to post-Shelby issues, is it more anecdotal these days, where we hear about the big cases like North Carolina and Texas photo ID, but we don't hear a lot about Pasadena, Texas, and we don't hear a lot about Galveston, and maybe we didn't hear much about the 5 counties, or at least I didn't know about it until today in Florida. Are people starting to write about this more in the academic community and doing research on some of these post-Shelby issues?
People were actually writing about this pre-Shelby. So I know there's a scholar at Indiana University, Indianapolis, who wrote a piece about how local officials were more likely to violate Section 5 than sort of statewide officials. And so his point was that we focus so much on like the state when we really do have to think about these local jurisdictions not complying with DOJ orders not to implement certain laws that were not pre-cleared. Shelby County is a prime example of a jurisdiction that implemented a voting change that had not been pre-cleared. So scholars were arguably looking at, local changes and local elections and trying to think through these issues. We also have websites that we look to. So there's a professor at Loyola University out in Los Angeles who has a website called All About Redistricting. And he posts all of these complaints from various election-related cases that detail how the litigation plays out. And so we definitely are taking a closer look at some of the things post-Shelby County, but we were thinking about it before as well.
And that's Justin Levitt's website?
Justin Levitt, yes.
Yeah, that's if you're interested in really up-to-date information about redistricting cases across the United States, that is a tremendous resource.
And, of course, Election Law Blog.
The Election Law Blog, right, through Rick Hassan. And then a third resource for lawyers, at least, is the Moritz College of Law at Ohio State University that has and they not only have posted decisions, they also have actually the pleadings filed in the cases. So if you're looking for a sample pleading, and this is now the opportunity for a commercial break here, because I want to talk a little bit about the Voting Rights Institute and some of the things that we're trying to do to kind of formalize the Voting Rights Institute going forward. We've received some funding to do this. And what we're really trying to do is provide resources for people like you who want to get involved in an issue, even if it's writing a letter, which is really important, and can get immediate results, which is what is great, particularly given the, how much it costs to litigate some of these cases. But we're also trying to replace, I think, a lot of information that was lost in Shelby County, and I'll give you an example. When Shelby County was decided and preclearance was no longer required for the jurisdictions, what we lost was way, way more than preclearance. What we lost was information, because every time a jurisdiction made a change that required preclearance, they had to do several things. The first thing they had to do was send a submission to the Department of Justice. So they had and explain why they were doing the decision what the procedure was being changed and why they were doing it. And they had to tell about what they perceived to be the racial impact of what they were doing. That document was a public document. You could get that like that instantaneously from the Justice Department, usually within 24 hours. If you said, I want to make a comment or I want to review this submission, we know you only have 60 days to make a decision, DOJ, but I want to know why they're doing this. The other thing the Justice Department required was you had to submit to DOJ with your submission the names of minority contacts in your community who were knowledgeable about the issue. So presumably, in order to do that, those minority contacts had to have some notice from the county of what, or the city or the state of what they were doing. Because otherwise, if DOJ calls them up and they say, you know, how do you feel about this moving of a polling place from the black church to the Klan headquarters? They go, you know, that might be a problem, but I hadn't heard about that. Well, that's going to raise a red flag. So those kinds of things now, those are gone. The other thing is that every 2 weeks, DOJ used to post on their website, and you could get it sent to you via email, a listing of all the submissions that had been sent in, state by state, to the Department of Justice for preclearance, identifying what the voting change was that was being requested. That's been lost. So one of the things the Voting Rights Institute is going to do, and ACS and the Campaign Legal Center are working on this, is to create a website that will try to replace some of that, to put up notices, to have people actually start posting things daily about what's happening in this community and whether it's an issue in the voting rights world. That's a gap we think that exists, particularly in the post-Shelby world, and not just in the covered jurisdictions. We're going to try to do it in all of Florida, not just 5 counties. We're not going to do it. We're going to do it in Illinois and places that weren't covered under preclearance before. So, and that's going to require a lot of networking, but we have lots of networks. We have the ACS network. We have the ACLU network. We've got so many people out there who are wanting to have information available to them about voting. And so this is an opportunity for us, I think, to do that, and also to provide opportunities for people if they want to get involved or if there's a problem in a particular area to say, well, we can link you up with somebody who can maybe has indicated, yeah, we could look into something on a short-term basis and maybe provide some help. So we'll have those legal, often legal resources, or in some cases, expert witness resources. So anyway, just with that commercial interruption, let's take a 5. I know we started a little bit late, so can we do a 10-minute break instead of 15? Okay, Zach? Okay. So 10 minutes and we'll resume here, and then we'll take up some comments about Florida redistricting, which I'm anxious to hear about. So, well, Chad is, I think, had to take a call, but he said he would be joining us shortly. He is in the, Victoria, he is in that far conference room on the, if you could, on the opposite side of the building. So one of the things that we want to spend a little bit of time talking about today, and Neil and Nancy are going to lead us, at least initially, in this topic, would be I'd like to talk about not only kind of developing some new approaches to voting rights matters or cases. You could talk about maybe some of the Florida redistricting litigation that has occurred here. Chad will join in and talk to us a little bit about special issues in voting rights cases, voting ID cases in particular. So, Neil, do you prefer to start, or would you want Nancy to go first?
I'm sorry. I was checking a text from my wife.
Well,
and I didn't hear what you asked me.
Oh, that's
I'm
not
a bad
fair.
boy, I admit it. But it has to do with getting my son to soccer practice.
Okay, well, that is important. The question
So
is,
that means me.
I think Nancy is, I think that dictates Nancy's going first.
Well,
And I'll finish my text.
There you go.
Well, I listened to Nancy.
well, so I would just start talking about redistricting in Florida. And I think it is an interesting situation because Jerry and I technically are on different sides of the V in the case, but I don't think that we're that we have different perspectives in terms of the overall goal and mission. And it has to do with the Fair District Amendments that were passed in Florida to really enshrine provisions of the Voting Rights Act into the Florida Constitution. And it's broken down into state legislative districts and then congressional districting. The idea for both amendments is that they're broken down into two tiers. The first tier focuses on making sure a district is not drawn to favor or disfavor an incumbent, and also that the minority voting strength is maintained or at least not diminished or diluted through the redistricting process. So those are the two primary objectives. The second tier deals with compactness and equal population size and some of the other redistricting principles. And so what the Florida congressional redistricting case presents is a tension between those two competing interests. We would argue in some ways they're not really competing because the voters have already informed us of which one's the priority of those interests. And again, for us, minority voting strength being paramount. And so when this case was filed, the ACLU was not originally involved. The ACLU did play a very big role in getting the Fair Districts Amendments passed, and we, wanted to make sure that the goal behind the amendments was recognized and, that there was some fruition to that. As the litigation developed, the ACLU did get involved, representing the NAACP State Conference as interveners in the case. And I think it's very important to note that at no time during the litigation has the NAACP tried to defend the maps that were enacted, but they have been very adamant about making sure that there's no dilution of minority voting strength in whatever remedial plan was put together. And the NAACP also had some very, significant concerns about the ways in which the plaintiffs in the case were defining packing, and were also interpreting the priorities of the amendments. And so where the case stands now is that the trial court did ultimately find that the redistricting plan was unconstitutional and violated the amendments. The court determined that it was possible to draw districts that were more compact, and in particular of, I believe, the 9 districts that were challenged, the court struck down 2 of them, 5 and 10, I believe, were what's now the new 5 and 10. And so essentially said, okay, legislature, you've got to go back to the drawing board. The legislature did that. The plaintiffs were not happy with the remedial plan. They still felt that there was unnecessary packing, that it still favored Republican incumbents, and that it still, as many have called, would result in a bleaching of the legislature. And even though minority voting strength would be protected in some districts overall, it would still be very difficult to enact any progressive legislation in the state or to even have really competitive elections. And so once the state issued its remedial plan, the court approved that plan. I believe, again, another paraphrase is that the court and the plaintiffs are not entitled to a plan that they like, but a plan that passes constitutional muster. And so where we are today is the Florida Supreme Court has granted review of the case, so it's going to skip the intermediate appellate process, and we'll just have to see where it goes. But the NAACP will remain involved in the case, again representing the rights of African American or Black voters, and the ACLU will continue to represent and serve as local counsel for the NAACP in that case. I think what the issue really shows, and I'm not going to pretend that it's a new problem, but it's being really exposed in this case and probably in some others, is the tension that's growing between minority communities and white progressives. And that's really just the best way that I can say it, is that some may view that progressive groups feel that it is satisfactory to spread spread the African American or black voting strength in order to increase the competitiveness of elections and to arguably increase the likelihood that laws that actually favor blacks and minorities in general that the way that the districting was done this time around will make that more difficult. Others argue that, while that may be true in the short term, the reality and the data shows that unfortunately white progressives still do not vote for black candidates in the same numbers that they vote for their own. And that when you have a white Democrat on the ballot and a black Democrat on the ballot, whites still tend to vote for the white Democrat. And so it's not about electing a particular party. That was the whole point of the amendments in the first place. But it's about making sure you have some racial diversity in terms of political representation. And that if you do not maintain majority minority districts, you will not have that. I know that there are other places, for example, North Carolina, where they seem to be pushing for more influence districts. Less than a majority, but still enough to be able to probably elect your candidate of choice. But the NAACP, and I think enough of the minority organizations here in Florida still believe that majority minority districts are necessary and that they cannot be compromised and replaced by influence districts. So I don't know, Jerry, what are your thoughts?
Would you let me address that issue quickly? And of course, I don't know anything about Florida, so I'm not talking about Florida.
Okay, well, just in the interest of full disclosure, I am one of the lawyers for the plaintiffs in the Florida case, and we are on the kind of a different page. So let me just talk about the Florida stuff just for a second. And it is true, and I agree, Nancy, with your opening statement that we both have the same perspective, I think, on a lot of these issues. But I think that, and here's where I see the most common ground. So there are a lot of states where the Republicans were in control of redistricting, Florida being one of them, where it was to the advantage of the Florida Republicans in the legislature to pack minority districts at the highest percent they could get away with. And that's true not just in Florida. That's true in every state where Republicans were in control. And the reason they do that is because if they can segregate minority voters into one district, they have the ability to bleach the adjoining districts of any minority voters who have a tendency to traditionally vote Democratic, and maybe a Democrat in an adjoining district might get elected. So let's pull some of those voters out of there, put them in the minority district to put a white Democrat or a Democrat having difficulty getting elected. The trouble, and you're absolutely right, that there are a lot of the civil rights groups have for many years said we need districts. First of all, it started out we need district at 65% minority in order for minorities. And back in the day, they actually did need 65% in many places in order for minorities to be able to elect their preferred candidate, not just 50%, because not only was voting racially polarized, but blacks turned out at such lower levels because of a long history of discrimination. They registered at lower levels because of a long history of discrimination, and they had more difficulty actually in casting ballots than whites. Well, over time, fortunately, the ability of black voters to elect a candidate of their choice was demonstrated, particularly at congressional district levels, but also at some of the state legislative district levels. And then it becomes a more difficult task, I think, sometimes at the lower governmental levels. But the percentages were actually, black voters in particular, I'll just stick with that minority group, were able to elect candidates of their choice in the 50 percentile range. And those districts were effective for minority voters. And I'll use the Virginia case that just was decided yesterday, they increased Bobby Scott, African-American, member of Congress, his district from 51 to 55. Now, Bobby Scott has for 20 years been saying, my district is packed at 51. I don't need 51% vote. First of all, I attract white votes, and it's not about me. It's about any black candidate who runs, in his view, could win with 40% black. And in fact, he was first elected from a district that was 40%. So now, I'm not saying that we should take all the majority minority districts and make them 40%, and Nancy and I certainly agree on that. But what I think happens is that, of course, minority incumbents are just like Anglo or white incumbents. when somebody comes along and says to a minority incumbent, your district is 51% African American right now, we'd like to make it 55%, do you have a problem with that? For the most part, they're going to say no. I mean, whites would say the same thing. We want to make your district go from 51% Democratic or Republican to 55 or 60, and as long as those voters are going to vote for me, sure, I wouldn't be opposed to that. And so what I think happened, though, is that there are two schools of thought among what I would call the progressive white community, one of which I don't subscribe to. I don't believe that we should take effective minority districts and say, okay, well, we've got an effective minority district. Let's divide it up in such a way that blacks they'll be competitive and they may be able to elect the candidate of their choice, whereas right now they're clearly in control. So let's drop it down to where it could go either way. And we can also create an influence district for minorities. So we get two districts. I don't believe that that's the case. First of all, I don't know what an influence district looks like. There's no definition of it. It's not required under the Voting Rights Act. And frankly, I think it's a dangerous slope to go down to replace effective minority districts with influence districts, whatever those are. The other thing is, though, at the same time, I don't believe that we ought to stick to an arbitrary percentage for what a minority district needs to have in it in order to be an effective district. I don't think we can automatically say it should be 60%, 55%. I think it's fact determinative based on a statistical analysis. You look at the district, you do reconstituted election results in it, you see how minorities vote. How did President Obama do in this district? Did he can't carry the district? Or you look at other statewide minority candidates who've run. We used to use, in the old days in Florida, Alcee Hastings, who ran statewide, and we used his district, his race, to do reconstituted election results. And I think as long as we're drawing districts that retain the effectiveness and the ability of minorities to elect the candidate of their choice, it's okay to drop the black percentage downward. Not downward to the point where it becomes dangerous for the minority community to elect a candidate. I think it should remain as an effective district. But I do think that we should not allow political parties to use minority voters as spare parts to just put them in districts and pack them into districts where, frankly, they do lose the ability to maybe have other like-minded legislators who are going to pass legislation that's going to be in their interest. So on that, I think both of us agree pretty much. So that's why sometimes you can find yourself on a different side of the also, I was the full disclosure again, not only did I litigate for the plaintiffs in the Florida case, and I'm still doing so, but I helped the Fair Districts people along with the NAACP and Leon Russell and so many other good people here in Florida draw those amendments up when they first were imagined.
I just want to say something about Harris County, because I don't want to get between my two friends on this issue at all. But something happened in Harris County that touches on this subject, and I'm going to argue the case at the Fifth Circuit the first week of December. And what happened in Harris County, in all counties in Texas, you have county commissioners, and they're all powerful people. In fact, people will argue the most powerful elected position in all of Texas is as a county commissioner in Harris County. And the governor in Texas doesn't have a whole lot of power. And in any event, we have 4 commissioners. It's required by the state constitution. There has been a historically protected African-American district in Harris County, and there had been a performing Latino district in Harris County. So essentially, however the county judge race, there's 4 commissioners and then a county judge is the chair, so to speak, of this board of governance. And however the county judge race went determined whether the minority opportunity or minority candidates could have meaningful influence on the board, even though minorities are a majority in Harris County. So what happened was in 2010, it was a terrible election for Democrats and minority candidates in particular in Texas. And a Hispanic had been gaining election and had been elected 3 times actually, in one of the commissioner precincts. She lost by just 100-something votes. She was replaced by an Anglo candidate who was now representing a county that, from a population standpoint, was overwhelmingly Hispanic, and he was not the candidate of choice of the population. So we filed a Section 2 lawsuit to claim first, and we also filed a Section 5 enforcement case, this was before Shelby County, to say it was a protected district. The Department of Justice disagreed and said because it hadn't reached the 50% Hispanic threshold, it wasn't a protected district. a decision I still disagree with, but in any event, it wasn't protected. So we had to demonstrate that it should be a protected district. And what it ended up doing is pitting the Hispanic community against the black community. And what was stated out there is that in order to draw the Hispanic district, you had to do harm to the black district. Now, in reality, the districts we had drawn for the Hispanic community raised the black voting age population in the black district from 51% to 55 and 57%. Those were our two plans. So it actually increased the African American population there. And in all of the election studies, the black district continued to perform for black candidate. And especially in Texas, you get a district over 50% African American. It's going to elect an African American candidate really over 35, 37%. And so we drew these 50% Hispanic districts. We had a judge in Houston, Vanessa Gilmore, appointed by President Clinton, and the county came in. The judge happens to be African American. The county came in and thought they could proceed by saying, look, you can't do anything for the Latino community because the only way to do it is to harm the African American district. And ultimately, the judge had found that we had prevailed on all of the items of proof we were to prove, but that we couldn't prove that we could draw a Hispanic district without damaging the African American district. And she relied on that, an argument that wasn't founded by any experts, that there were a lot of apartments that have African American citizens in it, and there couldn't be any guarantee that those people weren't going to just move and be replaced. So as a result, we're now going to the circuit who doesn't, much like the 11th Circuit, doesn't care much for Section 2 cases to begin with. It's going to be interesting to see how they deal with this argument. And it's unfortunate. I don't know what we can do about it. Obviously, it's not an issue you can flip a coin on. It's unfortunate that we can't somehow, on the good guy's side, so to speak, figure out a solution to this issue so that we're not doing collateral damage to one community or another. And the last thing I'll say about that is there's an area in South Houston that has an enormous Vietnamese American population that could probably support its own state house district. It doesn't have a Section 2 created district. It might get a protected district in redistricting, but it's also adjacent to a population of high African American population. So there is a tension there of preventing what I think would be the first protected Vietnamese American district in the nation from folks who are concerned it's going to harm them. And that's a hard-fought protection. Getting these districts, the African American district, the House districts. I mean, that was blood, sweat, and tears that did that, of course. And we ought to be super sensitive to their being undone. But in some ways, we're our own enemy at creating other needed districts.
It's interesting. I think Chad has touched on an issue here. We are going to see, I think, going forward, especially given the explosive growth in the Latino community. And we saw this in California first, but now we're starting to see it in other states that traditionally have not had a lot of Latino population concentrations, is the really, I don't want to call it tension between African American communities and Latino communities, because they try to work together. But when it comes to redistricting, at some point, you really somebody has to sit down and look at the numbers rather than, and by numbers, I mean the actual reconstituted election results, the racially polarized voting numbers, because you simply just can't make decisions saying, well, this district is 58% African American now or 60% Latino now, and it needs to be that percentage in the new plan or else we're not going to sign off on it. I think there needs to be a far more sophisticated review when it comes to really, it doesn't have to be a choice between whether it's going to be a African American district or a Latino district. We have the data and the map drawing capabilities now to draw districts that can accommodate both groups and should accommodate both groups. But I think this is an issue that is emerging. I think it also is going to apply for the Asian American community, which is also growing. In Texas alone, between 2000 and 2010, they picked up enough population in Texas to gain 4 new congressional districts. The only state that even came close. 90% of that growth was minority. 90% was mostly Latino and African American, but some Asian population too. You know how many districts that minorities got out of the new districts? It was like, where's Waldo? None. Texas gave them none, even though they accounted for 90% of the growth. So,
You have questions, Jerry?
yeah. Yes. Hi.
I have 2 about the Florida redistricting case.
Okay.
First, I'd be interested for both, actually, any of the panelists' assessments on what you think the state Supreme Court will do.
What the Florida Supreme Court will do with the case?
And I guess, especially I'm interested in what they're going to base the decision on, since these are new constitutional amendments. Are there sort of precedents in other states, or I don't know, are they just going to make it up? And then I'd also be interested if the Supreme Court does say that the map is, or the new map is unconstitutional, what relief do the interveners and the plaintiffs these want?
Okay. You want me to start out? Yeah. Well, first of all, I have no idea what the Florida Supreme Court will do. I'm hopeful that they will reverse, but the remedial decision at least. I do, at least we both, I think, Nancy and I, as we've talked about this, I think we both agree that, if the provisions are violated, there ought to be a remedy. And nobody's really, I think, the case really, there was a lot of e-discovery that the state legislature fought tooth and nail to prevent from coming out. We were successful in getting a lot of emails, which I think, frankly, broke the case open. Now, so I'm not sure what they'll do, but they do have the reason I'm hopeful, though, because, that's the one place in Florida where you're going to get, I think, a fair shake for the most part. You can't get a fair shake in a lot of the federal courts, in my view. Not yet, anyway. Some judges, but not enough. So we've already had arguments in front of the Florida Supreme Court this decade over these constitutional amendments. And so we've already been successful in getting them to rule that the legislative plans were problematic under the Constitution. So they've already interpreted the amendments to some degree. So there is some precedent for them having already looked at this issue. So I think they will do that, and they will continue to look at Florida Constitution, which is very unique in the area of redistricting. But the point that Nancy made can't be overemphasized, which is that we have to make sure, though, that whatever rules of law that we're advocating with respect to redistricting in the Florida Supreme Court are not inconsistent with the principles of the Voting Rights Act with respect to effective minority opportunity districts. And we can't be pushing for the elimination or the reduction or the dilution of effective minority districts in the state courts, while at the same time trying to hold out the argument that we're trying to protect those in federal courts. I mean, the arguments are going to be the same and should be in both places. Now, if we're successful in prevailing, it largely depends on what the scope of the violation is. That determines the scope of the remedy. So what we would argue is that I think you'd want to go back and try to put the districts in a position they would have been in but for the violation, which can be a difficult thing to do, and you certainly want to be mindful of the need to protect the existing minority opportunity districts consistent with federal law. So we would say, well, you really should go back and either adopt our plan or make the legislature do it yet again. The legislature in Florida, I think, is incapable of not violating the Florida Constitution. I mean, they've proven it so far each time they've gone to the well to do it, except for this most recent time. And again, Judge Lewis's opinion, thoughtful judge, but I think on this one, the remedy issue, he might have blinked because there wasn't maybe enough time to get an effective remedy for this. And so he just punted it, basically, and said this is going to be good enough, when it, in fact, was very much not dissimilar from the plan that he held violated the law. It's a long answer to your questions, but I hope that helps.
Yeah, and again, I mean, for the NAACP, their focus really is on what was formerly District 3, Corinne Brown's district, now District 5. And while arguments could be made, or have been made, that the district could have been drawn to be more compact, less snake-like, like what it looked like, and some may argue still looks like, we think that the legislature did tighten it up a little bit. But I think it was, and you can correct me, the first time during the remedial stage, or at least not during trial, where the plaintiffs actually proposed a plan that would move that district from a north South configuration to an East-West. And this is something that the NAACP had no notice about, was even under consideration, and absolutely opposed, because you're not only talking about changing the, traditionally how that district looked and was composed, but now you're also talking about, if you do care about other redistricting principles, violating some of those, such as communities of interest. Now you're going to be grouping communities that have no real connection other than, for some people, the color of their skin. And even the NAACP recognized that is just not sufficient. And so I feel comfortable saying today that a remedial plan that moves away from that north-south configuration will be very problematic for the NAACP.
And it may be problematic for us at the end of the day, too. We'll just have to see. But I do remember, and I represented Congresswoman Corinne Brown when her district was challenged under Shaw v. Reno in the 1990s. But at that time, her district, which is based in Jacksonville, went down over to Gainesville. Is that where University of Florida is? Gainesville. And then down to Orlando, and then down to Daytona Beach. And there was some thought of it going west to Tallahassee to pick up the minority population there. So, which looked like, a big, like that, which.
It wasn't pretty.
Yeah, and it got struck down. But the point was, and this is, I think, illustrates, why you can really work together on these issues, is we knew her district was going to likely get struck down by the federal court. So the goal was to reconfigure it in a way that improved its compactness, but still provided black voters with an opportunity to elect somebody in Congressional District 3. And we did that. And in fact, we did that with respect to every Shaw case I worked on. In Georgia, all the African Americans continued to be elected, even though their districts got struck down. North Carolina, Eva Clayton and Mel Watt. Florida, Carrie Meek and Elsie Hastings and Corinne Brown. And the only place where we really lost an African-American official was over in Louisiana, Cleo Fields, where he had no district to run in, so it isn't like we were able to protect it. So, Neil, you've been over there, and I'm sorry to have not gotten to you sooner, but I want you to weigh in on some of these issues. And I'd also like you to, if you have any thoughts on this issue, and Chad and Pranita, you as well. We talk about new voting opportunities or new opportunities to litigate cases. What about bringing more state court cases, which is a follow-up to that good question you just asked about the Florida Supreme Court? Maybe with the federal bench not being very receptive to Voting Rights Act cases under the Voting Rights Act, maybe there are opportunities in states to bring state court cases based on the state constitution, which oftentimes its equal protection clause may be a little broader in scope than the federal court and the Supreme Court has deemed the equal protection clause in the federal.
Well, there was a good deal of thought to going to state courts maybe 15 or 20 years ago. And New Jersey is one example where that succeeded. Mm-hmm. So it's just a judgment you can make about your own state appellate processes. You pretty much know what the federal courts are like nationwide. I mean, I can tell you what the 10th Circuit is. I can tell you, what the 9th Circuit is like. State courts are also just, idiosyncratic. They might be good. Florida has had a remarkable run of pretty decent control by the forces for good in the state Supreme Court. Maybe you disagree because you know more about it now than I do, but that's just a choice. And sometimes it's a choice of, I'm not that comfortable in going to state court, but I know how to litigate in federal court, and it probably won't make much difference. So, but there are things, some of them have, just procedural stuff that helps. But in general, I think state courts are less likely to interfere with the election process than the federal courts are, because for the most part, they came out of the election process. So overall, I mean, you can obviously say, your district judges and the entire district with 13 judges is pretty slim picking. So you want to take your shot at the state court, but that's just really a choice you make because you know your judiciary better than anybody else.
It's interesting, but one of the things that I represented national political parties. So in representing, say, the DCCC on redistricting, one of the things that I think we discovered early on is that state court judges are much more partisan. Now, they do come out of the election. Oftentimes they're elected. They usually are elected pursuant to a party primary. In redistricting cases, even if they are based on claims about race, are really partisan cases for the most part, masquerading as racial cases when the major political parties are involved. They can't bring political gerrymandering cases, right? Because you can't win those, and there's no real effective relief affordable. So political parties, the major political parties, the RNC, DNC, DCCC, you name it, they bring voting rights cases because that's the only claim they can really bring that will bring about the political result that they're seeking. And then civil rights groups are forced to jump into those cases to protect minority voting rights and make sure that, as the two big buses proceed down in the litigation, that the little Volkswagen bus, the NAACP in the middle, doesn't get scrunched, right? So, that's the way the cases proceed. But the one thing that we discovered, certainly litigating in Texas, and Chad, you correct me if I'm wrong, but when we brought the redistricting cases in 2001, we knew the Texas legislature was going to deadlock. Republicans controlled the Senate, Democrats controlled the House at that time in 2001, and we knew they were going to deadlock. So if they're going to deadlock and not come up with a plan, who's going to draw the plan?
Courts.
It's the courts, right? Is it going to be the state court or the federal court? There's a case out of the Supreme Court of the United States that says that if you have a case pending in state court and federal court about redistricting, the federal court has to stay its hand and let the state court go first, but not give it an unreasonable amount of time. They can even put a time limit on them and make them go first. So in Texas, we had to file in state court and in federal court simultaneously, and we wanted to be the first case filed, because if we weren't the first case filed, then the Republicans would file in a friendlier forum for them. And, of course, that's exactly what they did. They filed in Houston. We filed in Austin state court. And the two state court judges, they were so partisan, neither one of them would back down. They both scheduled trial to happen on the same day in different cities. And so we said, well, we can't do this. So we went to the Texas Supreme Court, which is not a friendly place, by the way, because they're all Republicans. But the Democrats, we went up there and we argued that we were the first filed case, by golly, and we should be in Austin trying this case. And they ruled 7-2 or 8-1 in our favor, that we were going to go first. So we tried the case in Austin. We got the decision we wanted out of the judge after a number of proceedings that are not relevant here. And we won a plan. They immediately appealed, and the Texas Supreme Court said, yeah, state courts really shouldn't be drawing these plans. We'll defer to the federal court. So they wiped the slate clean. Now we were in federal court. Again, it was the court of our choice because we had filed first, and we had a trial in federal court right after the state court trial, and we prevailed in that one as well. The opposing lawyer in that case, by the way, Ted Cruz. Have you heard of him? He was our opponent.
Jerry, can I say something about the state constitution point? So state constitutions are actually more favorable than the U.S. Constitution when it comes to the right to vote. Almost every state recognizes an affirmative right to vote. The U.S. Constitution does not. It's all by negative implication, with the exception of the 14th Amendment, and the court sort of read the right to vote into the Equal Protection Clause. The problem is that state courts lockstep their reading of their state constitutions with the U.S. Constitution, when it actually should be the other way around. The Voter Qualifications Clause of Article 1 says that qualifications for electors for federal elections is actually determined by who can vote in state elections. But the courts take a different tact, and they look to the U.S. Constitution and they look to U.S. Supreme Court pronouncements in trying to articulate what voting requires under their own state constitutions. So the problem isn't the state constitutions. They're actually really good for reading expansive voting rights. The problem is the state courts interpreting their state constitutions in line with the U.S. Constitution.
Well, I would just add the problem, at least in Texas, is I don't want Jerry to give the misimpression that people can bring voting cases in state court in Texas and expect an outstanding result, because I don't think the Texas state judiciary is capable of handling a case concerning voter rights in a fair way. And I don't say that as a partisan statement. There are a number of Democratic judges that I don't think should be hearing voting discrimination cases. There's certainly a number of Republican judges that can. There's a number of Republican judges that could, but due to electoral outcomes are unable to do the right thing in these cases. Again, because these judges are elected and because especially the Tea Party on the right has so controlled primary outcomes in judicial races where nobody's paying attention. I mean, I think there's 87 elected judgeships in Harris County, and I'm one of the more active trial lawyers in the county. I can't list all 87. I don't make informed choices about all those benches in Harris County. So people do that based upon endorsements, and as soon as you, whether you're on the left or the right, you anger that wing, you're done. And so judges in state court are hampered from doing the right thing. Many of them, unfortunately, wouldn't want to do the right thing. I also believe that the times they are changing and that diversity is coming to the Texas court system. And if we're going to start testing some of these issues, because we do have some great provisions in our state constitution left over from the Reconstruction era, even though our Constitution was unfortunately rewritten after the Reconstruction version. But it's got some great provisions in it. Before we have the courts handing down some opinions we're going to have to live with for eons, let's have a better judiciary to do it. So, you know, the Fifth Circuit's no great place to go for voting rights litigation. I think everybody would agree it's one of the last places you'd want to have to go with one of these cases. But I still think due to resources, state court judges by and large, and I've practiced in a number of other states, this has been true in other states I've been in, have very little resources. They don't have law clerks. They are handling a divorce, a child custody, a homicide case. I mean, they have all kinds of other things. They don't have the expertise and won't have the time to develop expertise in these areas. And in federal court, you get money, you get law clerks, you get apparatus, you get a network of judges who a lot of times will self-identify with a particular area. So they'll call on another federal judge. I know you do a lot of voting rights. I've got this case. Let's help me work through the legal issues. So that's what I would say about state court. I would like to just say something about trial practice, because I think that it is an issue that doesn't get addressed enough by people who do this work. So some of you, I hope, will leave this room and return to your communities or watch this video, return to your community and pursue voting rights cases. I think it's important when people to undertake these cases to put together a team. So Jerry and I, work on a lot of cases together. I can't think of any I've handled by myself. It's always important to get other people involved. And there's I shouldn't say a lot, but when people get interested in civil rights and voting rights, they necessarily focus on the law and the emerging trends and even the judges and the briefing, and all that stuff is terribly important. And of course, once the case is tried, it's really the only thing that matters. But there's also a lack of development of trial advocacy skills among people, in my view, that do civil rights work. And part of that is because they don't get to try very many cases. You might try one case a year, and this is true across the fields. People who do criminal work, people who do personal injury work, corporate litigation, they talk about the dying trial, and the trial really is dying. But we have seen cases won in hostile courts with hostile law in an environment we never should have prevailed at because something went right at trial. A witness did something because of good advocacy that nobody expected. And now the judges can't do what they wanted to do because the record just won't allow them anymore. And that's an area that I think, as things are getting harder and harder for us on this side, that we have a real opportunity to improve and practice. And I think the Voting Rights Institute's a great start to that. And so anyway, that's my little soapbox about trial strategy. But I think it's something that's got to be focused on. Putting on your witnesses. Who are the best lawyers in the group for advocating to the judge? Who are the best lawyers for presenting this type of witness, this type of expert? Don't get too caught up. I see a lot of lawyers who you would think they were putting on a Broadway show. They've rehearsed this thing so many times. And when you watch a witness, I've handled, 60, 70 trials, many of them jury trials, almost all of them as first chair. I don't know how many witnesses I've examined. And I've done it every which way, and I'm sure I still do a lot of things wrong. But one thing I can tell you is absolutely wrong, is if you practice with your witness for weeks at a time and then put that witness on the witness stand, it will be terrible. I don't care what the subject is or how talented you are or how talented the expert is. It needs to be a fresh discussion. And I think another thing, and I promise to shut up about this, one other thing I would add is when we examine experts, as people like us who do this kind of stuff, we talk about ecological inference and ecological regression and CVAP, and we're throwing around all this stuff. And we're in front of a federal judge who a lot of time went to some of the best schools in the country and is clearly, recognized in her field. We got to step back, though, in these cases, A, because it's persuasive, and B, because it's necessary, and tell these stories through these witnesses from the beginning. So when we have an expert, let's not assume the judge knows what ecological inference is. Let's have the expert explain it. It's persuasive, number one. Even if the judge knows what ecological inference is, it reinforces his or her understanding to be able to write on it. So there's a lot of things from a trial advocacy standpoint. And when I say put together a team, you got to have people that can come up with the big ideas. And I'm not one of those people, I don't believe. But you also have to have somebody that's willing to get down and work, answer the discovery, and go climb through the 16 boxes of documents. And I'll do that. That's not something that I shy away from. You got to have people too who can take the deposition and that can present the witnesses. So if you have a big case, think about putting together a team of people with different strengths, and then let everybody do their strength.
It's a good discussion point. Did you want to say something, Daniel? No, because. And Neela, you probably should weigh in on this too, and others as well. And Nancy, you've tried cases. And what we find as putting together these litigation teams is that, like in any other endeavor, various people have various strengths, and you can put on witnesses. And we usually would discuss who the best lawyer was on our team, and we had 5 lawyers on our team. Who were, going to be doing the trial. And we recognized early on that the judge in the voter ID case, Texas federal court judge, Chad has been cited in Texas as one of the best trial lawyers in Texas under the age of 40. So he's known. And it was pretty clear from day one that she liked him, right? It wasn't that she didn't like me. I mean, who could not like me after all? But we decided that he would be our chief person at the podium every time she had a question. And it worked really well because DOJ, which was involved in the case, they stumbled early on in the case several times. And as a result of those stumbles, she would turn and she would say, well, Mr. Dunn, why don't you see if you can get this issue resolved? So suddenly we were like, being called upon to, what do you think about this? And we would propose there's a solution here, Judge, that maybe nobody's really come up with, and here's how we do it. So strategy calls like that make a huge difference, I think, and it was early in the case. And then, so my job was much more limited in the case than Chad's.
But in the D.C. case, you took the lead because you had the connection to the court.
Exactly. So there, the federal court deferred to me. And so I was the chief person. But you have to make those judgments. Sometimes you have to even make them on the fly about who's the best person to get up right now. And you can talk among yourselves. And those things they never teach you in law school, obviously, anything remotely close to this topic about how to strategize and what depositions you really want to take. And I teach law school, so I don't know if you teach that, Benita. But in my classes, I don't really get into this very much. I mean, I talk about the principles, and I talk about, how Citizens United, and I'll just say this, and this is a new theory. So here's a new constitutional theory for you to take with you, and you can read my law review article, which is coming out soon on this topic. So why is it that the Supreme Court of the United States says that there's a First Amendment right of corporations to spend unlimited amounts of money in elections to influence my vote? And then that's a First Amendment right that they have, when my fundamental right to vote is not entitled to the same protection. I mean, when I vote, I'm su voto e su voz. My vote is my voice, right? So that is my way of expressing my views. And so why isn't my right to vote entitled to the same fundamental protections under the First Amendment that corporations have? I think I can make a much stronger case that I ought to have more First Amendment rights than a multinational corporation.
We'll write a response to your piece called "The Right to Vote is Not Fundamental."
Okay. Because it's not in the Constitution?
No, because the court doesn't act like it is.
Oh, well, the court doesn't act like it is. But in Yick Wo versus Hopkins, it said the right to vote is a fundamental right, preservative of all other rights.
Yeah, the standard of review doesn't reflect that at all.
Well, yeah. Well,
And in the Arizona case, they talked about how the right to vote was such a...
Yeah, a partial answer to Jerry is what I talked about before when they switched the standard of proof on this. And part of the reason they defer to the election structure is elections got to be held. They got to be managed. People have to make decisions. And they decided we're not going to say, well, a 30-day cutoff for registration is okay, but 29 isn't. They're not going to get into those fine things. They're just going to defer to the managers of the elections. And what that is doing is saying we are not going to apply strict scrutiny to anything in the elections, in the running of elections. That's really what they did. I mean, if you come in with a race issue, they may apply it. But part of this verdict standard is, they openly said, we're not going to apply strict scrutiny. And that's in part an answer to your question. I wanted to add to what Chad was said on a slightly different level, not in putting together trial teams, but the people who do voting rights nationwide are a group of people without big egos, with a couple of exceptions. And they share their information.
Who are not at this table.
That's a
the big
compliment.
Ego people.
Anyway, I mean, maybe you don't know these people. You never knew anything. Maybe you don't know these people. There's only 2 or 3 dozen people, nationwide that have been doing this, except maybe one case. I mean, there just aren't that many people. They know each other. They share information. They share briefs. They share ideas. One of my best sources of information is a guy you can call up, and he will give you 5 reasons why your idea is wrong. I mean, it's a very valuable tool to have. I don't necessarily and often don't agree with them, but once you get to hear these people, or once you can reach them. And call them up. They're very open about their ideas because it's not a competitive business. There's more work than can possibly be done. So there's exceptions to that too. But anyway, it's a good group to be a part of because, it helps to have somebody out there to say, that's crazy, or that's a great idea, or I did this 5 years ago, here's a brief. So I want to throw that out there.
And my only thing that I'll add is, Jerry and Chad were talking about litigation strategy in terms of who goes to the podium and who takes the lead. I'll just make note for younger lawyers that, of course, it always makes sense to defer to the people who have the experience, but you're never going to get the experience if you don't do the work. So at some point, and hopefully, I was lucky doing South Carolina and Texas and working for VRP, that I was around people who supported me playing a lead role in those cases.
Today, these cases, they're not about states' rights. They're about civil rights. They're about human rights. They're about voting rights. And we will continue to fight. It will be a long struggle, but there's nothing stronger than a made-up mind, as Dr. King used to say. And our minds are made up. We're going forward, and we're going to create a network of people who are going to make sure that we ultimately bring about that fundamental right to vote, right where it belongs, at the centerpiece of our constitutional interpretation. I want to thank you all for being here today, and again, thank you for my panelists. All in the night, thank you very much for hosting. You were awesome.